Broadcast is now starting. All attendees are in listen-only mode.
Hi, my name is Beverly Bolnick, Vice President of Sales and Marketing at NMP, and I would like to welcome you to National Mortgage Professional Magazine's webinar titled The TRID Countdown Begins Now, sponsored and presented by REMN Wholesale. I would like to thank all of our webinar attendees for taking the time out of their busy days for this very valuable and informative webinar and our ongoing series of webinars. If you have questions during the webinar, please be sure to send them via the Questions tab on your GoToWebinar console, and we will try to answer as many questions as possible at the end of the webinar. Since this is a really hot topic, I'm sure we're going to get a lot of questions on this webinar, so we're not going to be able to answer all of them, but we'll try to answer as many as possible. Before we get started, we'd like to ask the audience a few questions. I'm going to put up 2 questions up on your screen. The first one is going up right now. If you could just answer on your screen. We just want to see who we have with us today. Just answer whichever one applies to you. Okay, I'm going to give you a few more seconds to vote, and then I'm going to close it up and share the results. Okay, I'm going to close the poll up right now, and I'll share the results with you. So 27% of you are brokers, 51% are lenders, 4% are realtors, 4% are attorneys or closing agents, and 14% said other. Okay, we're going to launch the next question up on your screen. We are now less than 60 days away from TRID implementation. How prepared are you? You can answer on your screen right now. I'm going to close the poll up in a few more seconds. Okay, I'm going to close it up and share the results with you. So 4% of you are great and ready to roll. 49% of you said still working on the process but feel good about it. 39% said putting together the pieces, and 8% are full-on panic. Well, those 8%, I hope that we can help you today if you're not in a full-on panic. Without any further ado, I'd like to turn the webinar over to Carl Markman, who is the Director of National Sales at REMN Wholesale.
Thank you very much, Beverly, and thank you everyone for attending. We're very, very proud of the overwhelmingly positive response for all of you to attend this webinar. Many of the people that registered are now able to actually view and listen to today, so we'll be recording this and sending this out to everyone so you can review it. But with only 42 business days remaining until TRID is implemented, it's very important that as much information is out there as possible. So we're very proud to have Ben Olson present for us today. So I'd like to introduce Ben and get the presentation going. So thank you very much.
All right. Thanks very much, Carl. And without further ado, I'll just get into it. What we've done with today's presentation is to assume that folks have a fair amount of familiarity with the rule, and to really focus on some of the most challenging issues that are out there, or the issues on which there seems to be the most confusion. So while we'll be doing an overview of some of the key requirements associated with those issues, the idea is not to sort of take everyone through the basics. With that said, here's one slide that runs us through the very basic requirements of this rule, which is for applications received on or after August 1st of this year, the GFE and the TIL will be replaced with the loan estimate. The items constituting an application will be narrowed, which means that the loan estimate will be provided earlier in the process than the GFE and the TIL are today. The tolerances imposed by HUD in 2010 have been tightened and are now subject to CFPB enforcement and a private right of action under the Truth in Lending Act. In addition, the HUD 1 and the final TIL will be replaced with a closing disclosure. that must be received by the borrower with at least 3 business days before closing, which means that while changes are permitted after that point, and we'll talk about those, this document actually has to be assembled. All the information necessary to populate it needs to be there in time to deliver it 3 business days before closing. And then finally, the other biggest change is that the lender will now be responsible for all of that HUD-1 settlement content. Although they can delegate it to a settlement agent, they're nevertheless going to ultimately have the liability for that. All right, so starting with the scope of this rule. This is going to apply to pretty much all closed-end consumer credit transactions secured by real property, other than reverse mortgages. So it's closed-end transactions, so it's not going to apply to home equity lines of credit, and it's secured by real property. So it doesn't apply to a loan secured by a mobile home or a dwelling that's not attached to land. Now this creates some interesting questions about what is really real property for purposes of this rule. And ultimately, federal law defers to state law on this point. So you have to look at what does state law treat as real property and what doesn't it. And one of the toughest questions that's come up relate to co-op loans. If you go through the rule, the guidance addresses how to disclose co-op fees and other things on the loan. The forms were designed with the idea that they could be used for co-op loans. But unlike Regulation X today, the TRID rule doesn't specifically pull in co-op loans regardless of whether they're secured by real property. And in some states, a loan that is secured by shares in a co-op would not be considered secured by real property because those shares are considered personal property. Now this has raised a bit of an issue and what seems to be an unintended consequence for the Bureau, where there's some uncertainty and some need to look at each state's law and in some cases the terms of a particular co-op agreement to know which bucket it fits into under the state. What the Bureau has said informally is that the intent was to apply it to co-ops, and the Bureau's intends to sort of apply it broadly or interpret it such that it would be a co-op even if it's not titled as personal property under state law. If it's subject to the state's real property transfer tax or real estate law, that would be enough in the Bureau's eyes to consider it real property for purposes of this rule and allow you to provide these disclosures. But the problem is the penalties for getting this wrong are relatively significant. If you give the wrong disclosures, you have the risk of a private suit or rescission under TILA, and of course if this loan needs to be sold to an investor, you run the risk that the investor is just going to refuse to buy it and it's going to have to sit on the warehouse line or in your portfolio. So there's not a great answer on this yet. The Bureau won't be changing the rule. I think what a lot of folks are looking at doing at the moment is to avoid the risk just providing both sets of disclosure, or at least providing the new loan estimate and closing disclosure as well as the truth in lending, the old truth in lending disclosures, the Fed box, since that carries a private right of action and rescission, and that way you're covered. It remains to be seen whether folks will dig in and do the state-by-state work to determine what's real property and what's not, but that's where things stand on co-ops today. And that takes us into the question of liability, and I won't belabor this because it gets fairly complex, but a couple of important points here. So this regulation combines disclosure requirements under the Truth in Lending Act and the Real Estate Settlement Procedures Act. And as you can see on the slide, Truth in Lending Act provides a private right of action for certain violations of certain provisions, and then it provides actually statutory penalties for violations of a subset of those, like the APR and the finance charge. And so what that means is, depending on which provision of the Truth in Lending Act is in play, different liability attaches. Whereas today under RESPA, there is no private right of action, private liability for violating the requirements. So the TRID rule pulls that all together and combines the requirements. That doesn't mean there's a private right of action or liability for everything, but there is for certain provisions that rely on TILA provisions that themselves have a private right of action. So what does this mean for wholesale? It's one of the questions we were asked to address today. And as you see on the slide, currently neither the Truth in Lending Act nor Regulation Z, which implements it, apply to brokers. However, Regulation X, which currently implements RESPA, does permit brokers to deliver the GFE as long as they otherwise comply with the relevant requirements, and the creditor remains responsible for ensuring their compliance. But there's no private right of action for violations of these provisions. Now they're going to be in Reg Z because of TRID. So what does that mean? Well, as already noted, each provision of the TRID rule carries the same liability as the statutory provision on which it's based. So you go through and you look, basically every provision of this rule, give or take, relies on TILA, RESPA, and the Dodd-Frank Act, because the Bureau was trying to construct a rule that, were anybody to decide to sue them and challenge the validity of the rule, would have the maximum possible support. But it matters which provision of TILA it relies on. Specifically, is it in Part B? And most of the provisions in here are based on Part A, and that includes the provision that assigns responsibility for providing the loan estimate to the broker if the broker receives an application. So looking at it today, it appears that a broker would not be liable, would not be subject to suit, for failing to provide a loan estimate within 3 business days after receiving the application. Now, if a if a wholesale lender accepts that loan package with the defect in place, they could become responsible and they would be subject to a private right of action. But it's also important, and the last set of bullets on this slide is that no one should forget that this is still subject to CFPB enforcement authority. So just because a borrower or a plaintiff's attorney can't file suit doesn't mean the CFPB can't come after you. And the Bureau has the ability to go after any person, lender, broker, settlement agent, who violates a federal consumer protection statute or regulation. That includes Regs X and Z, or engages in unfair, deceptive, or abusive acts or practices. And the Bureau has very strong penalty authority. It can impose penalties up to $1 million a day for knowing violations. It's $25,000 a day for reckless violations and $5,000 for just ordinary violations. But basically what that means is the penalties can add up very quickly, and the Bureau can impose, more or less the penalties that it believes is appropriate to both discipline the person who engages in the violation and deter others from engaging in violation. All right. So now we're going to talk about the effective date, and I'll touch on here the Bureau's announcement yesterday. But generally speaking, the rule applies to applications received on or after August 1st. And this is a rule where the lender or the broker is going to need to be able to flip the switch. And by that I mean it's not permissible to start using these forms early or to start complying with this rule early in most respects. So your systems are going to need to be able to track the application date and provide the correct disclosures accordingly. So if you get an application on July 31st, you're going to issue a GFE and you're going to close that loan with a HUD-1. If the application were to come in the very next day, you're going to be issuing a loan estimate and closing with a closing disclosure. So that means these are going to be running on parallel tracks for a period of time this fall, probably into the winter, where we'll have some loans that are still under the old regime closing alongside loans that are under the new regime. And so the systems are going to have to accommodate that. Now, very quickly, what constitutes an application here? Hopefully everybody's familiar with this already, but it is the submission of 6 items for the purposes of obtaining an extension of credit: name, income, social security number to obtain a credit report, property address, estimate of property value, and loan amount sought. What's gone is the historic RESPA 7th catch-all item for any other information deemed necessary by the loan originator. That is gone, so we now have a standardized definition of application that will be the same for all transactions. So once you have these 6 items, then you have an application and the clock begins running to provide a loan estimate within 3 business days, and that is regardless of whether it is the broker or the lender who receives this information. Now you may attempt to sequence the collection of the items. The Bureau's endorsed that idea, so you can ask the borrower for everything but the property address, and you don't have an application, and then you can ask them for additional information and ask for the property address last. That's perfectly permissible. What's not permissible, though, is to refuse to accept any of these items. So if the borrower comes in and says, I want to give you these 6 things and I want my loan estimate, you would violate the rule if you refused to take the information. All right. So now what does it mean, before we start talking about leaves on file, what did yesterday's announcement by the Bureau mean? And you may have seen headlines, and some of the headlines said things like, Bureau delays effective date, or Bureau provides, safe harbor period after August 1st. And I think it's really important to understand what it is the Bureau actually said, so that no one finds themselves in the mud because of this. What the Bureau said, actually, in its document, in a letter from CFPB Director Rich Cordray to some members of Congress who'd requested an extension, is that the Bureau wasn't extending the effective date. There is no extension of the August 1 effective date. But in examining and enforcing compliance with the rule after August 1st, the Bureau would be sensitive to good faith efforts towards compliance. So this is the Bureau's way of saying they will be understanding of the fact that compliance may not be perfect right away, and that they've communicated that to the other federal regulators. Now that's very different than saying there will be no liability for this period. So there's still a private right of action here. A court is not subject to this good faith efforts towards compliance standard. So a borrower who chooses to sue will be able to assert a violation without having to worry about the lender's compliance efforts. And it's also important to note that, of course, what the Bureau's done here is reserved for itself the ability to determine what is a good faith effort. And so while I think that's, it's helpful, and it's good to know that the Bureau is not expecting things to be perfect on August 1, I would not advise anyone to, rely solely on that and to take every step possible to protect yourself against liability beginning on August 1. So the question then becomes, when August 1 hits, what do you do when you've got a lead in your system and that lead already contains the 6 elements that make up an application under the new rule? And the Bureau actually has guidance on this, and I've reprinted it here on your screen. I'm not going to read it to you word for word. It's a little hard to follow, but I wanted to make sure you had it. What this says is that if a creditor has received the 6 items constituting a TRID application before August 1st of this year, in this case, in the example, it's on July 31st, then the TRID rule does not apply. You don't provide the loan estimate. You don't close it with a closing disclosure. If, however, that application came in the next day, then the TRID rule would apply. So what this means, at least what I understand this to mean, and there has been some confusion about this, but this is the way I read it, and I think this is the way others read it as well, is, if you've got these 6 items sitting in your file today or on July 31st, that does not mean that come the next day, all of a sudden the 3-day clock is ticking. It means that application or incomplete application, is and shall remain subject to the old rules. Now, if the borrower reapplies, then it's a new application and it would be subject to the TRID rules. And then there's a little wrinkle here, which is this guidance specifically talks about situations where you have the 6 items in your file already before August 1st. If you've got 5 of the 6, so you have everything but property address, and then on August 1st they give you the property address, then you've received the 6th item after the rule takes effect, and the rule is going to apply. So this is very confusing. It's very complicated, but this guidance is here, and what I've shown you on your screen is put out by the Bureau in writing. It's actually part of the Code of Federal Regulations. It's entitled to deference by courts, so this is binding guidance that you can count on. All right. Let's talk about pre-approvals and pre-qualifications. This is another subject that has been an area of confusion for folks. And basically what it comes down to is this. You cannot require a borrower to give you verifying information, pay stubs, purchase and sale agreement, whatever it might be, as a condition of providing a loan estimate. If your consumer wants to give you those 6 items, they don't want to give you anything else, they have a right to a loan estimate. You can't refuse to take those items, and you can't require them to give you documents. However, you are permitted to ask them for documents, and you're permitted to accept documents if they give them to you, particularly if what they want is not a loan estimate, but they want a pre-approval or a pre-qualification. And the important thing here, and the Bureau amplified this in a webinar it did last week, is you got to be very clear in how you communicate to the consumer. So if you're telling the consumer you need their pay stubs, you better make sure that you're telling them that in connection with a pre-qualification or a pre-approval, that you're saying, if you want a pre-qual or a pre-approval, I need your pay stubs. It does not allow you to delay providing the loan estimate. All right, speed up a little bit here. So we've got the tolerance buckets. And I just want to touch on the ways in which they differ from the standards today under RESPA. And 2 things are most significant. On the left-hand side, you'll see in the 3rd blue box, amounts paid to an affiliate of the creditor or broker are now always in the 0 tolerance bucket. Doesn't matter whether you allow the consumer to shop for that or not. In addition, below that, if shopping is not allowed for an unaffiliated third-party service, then it's going to be subject to the 0 tolerance as well. All right. So what does shopping mean? Because it's a very important concept here. As laid out at the top, if you do not permit a consumer to shop, 0 tolerance applies. If you permit them to shop, then the 10% tolerance will apply unless they actually do select their own provider, and that means selecting somebody who's not on the list of settlement service providers. In that case, if they choose their own person, then the tolerances don't apply at all. There obviously is a lot of value to allowing a consumer to shop because it gets you the flexibility of the 10% tolerance and may get you out of tolerances entirely. So how do you do that? First, you have to actually allow them to shop subject to reasonable requirements like licensure, insurance. The loan estimate must identify the services for which the consumer may shop. There's a section on the loan estimate just for that. And then the written list of providers must identify at least 1 available provider for each service and inform the consumer that they may choose a different provider. If they choose that person on your list, 10% tolerance. If they choose somebody who's not on your list and you accept that person, tolerances do not apply. All right, so here's the example. Creditor selects the appraiser appraisal fee is 0 tolerance. Creditor permits the consumer to select a licensed settlement agent, but the consumer selects the agent on the creditor's written list of providers, and the title fees are subject to 10% tolerance. Creditor permits the consumer to select a licensed settlement agent, and the consumer selects an agent not on the list, then they're not subject to tolerances, although estimates must still be based on the best information reasonably available. Okay, so what happens if, because the written list of providers must be provided at the same time as the initial loan estimate, 3 business days after application, what happens if you've added, if a new service is discovered and added later on? You discover you need a termite inspection. And there's really no provision in the rule that allows for a revised or subsequent list. So it's been a topic of a lot of discussion. there is commentary and official interpretation here that says that if you fail to provide the list entirely, right, you never provide it, then those amounts are still subject to 10% tolerance rather than the 0 tolerance, as long as you've otherwise allowed the consumer to shop. You disclose it as a shoppable service on the loan estimate, and you would allow them to select their own provider. But notwithstanding what that guidance says, the Bureau said on its webinar last week that in these circumstances, if you do not, when a new service is required in the course of the origination, if you don't provide a revised service provider list, then the 0 tolerance will apply. So the Bureau is saying there is a mechanism for providing a revised list, and you've got to provide a revised list with that new provider for that new service if you want the 10% tolerance. Otherwise, it's 0 tolerance. This doesn't seem to reconcile with what's in the Bureau's official interpretations, and so it raises the question of, well, which of these are you going to follow? And if we were going to court and having an argument over this, then the official interpretation would control. But the reality is that the Bureau stated its position in this webinar, and so I think it's reasonable to expect that a lot of investors and some lenders will determine that they're going to err on the side of caution and follow the Bureau's position, and either apply the 0 tolerance anytime a new service is added after the initial loan estimate is provided, or when a new service is added, provide a new settlement service provider list and apply the tolerances accordingly. All right, 10% tolerance category. Just want to highlight an important difference here in practice. The excuse me. The rule today is that the 10% tolerance applies in the aggregate to all the third-party services that fit within that bucket, and they can go up by as much as 10% for any reason or no reason. If they go up more than that, then you need a change circumstance or other exception. But the way many have interpreted HUD's existing rule is that if you have a change circumstance and it ups that bucket by 6%, or let's say 7%, to use the example on the screen, then you can still redisclose and reset the tolerance at the new 7% increase and have 10% above that new amount. The Bureau's made very clear that that's not the case, that you need cumulative increased charges exceeding 10%, and only at that point can you redisclose and reset the tolerances. That doesn't mean you can't redisclose the 7% increase. It's perfectly permissible, but it won't reset the tolerances. Now, the 3 days, the Bureau has also been clear, runs from when you learn of the last change that pushes you over the threshold. So this is just another example of how important it is to be able to track all of this information. And as I just discussed, again, and this is the language reiterating the fact that you are never prohibited from providing a new loan estimate. For instance, with that 7% increase, you can advise the consumer of that and give them a new loan estimate. But your systems need to be sophisticated enough to know that you haven't reset the tolerances by doing so. And so, there are different practices out there. Some folks have decided they don't want to run the risk of having loan estimates, in the file that don't reset tolerances. So they're not doing it. Others are going to provide a loan estimate in that circumstance. Okay. The tolerance comparison chart. So that is something that exists today on the HUD-1, but does not exist on the loan estimate or closing disclosure. So this disclosure does not tell the consumer whether you have complied with tolerances or not. And that is something you are expected to track on your own, just like you track the finance charge and points and fees today in your LOS or in worksheets you keep in the file. That's what you'll need to do with the tolerances. However, there are, in circumstances where you've exceeded tolerance and you need to cure, there are specific disclosures, and that's what I'm going to show you on this slide. And there are basically 2 places where you disclose this. On the closing disclosure on the bottom of page 2, in the red text here, you would just add to the lender's credits a specific language stating how much of that credit is for an increase in closing costs above the legal limit. So you have a total credit of $500 and then a disclosure saying that $200 of that is for a tolerance cure. And you have a corresponding disclosure at the top of page 3, where you're also disclosing that the total closing costs have exceeded the limits by $200 and referring the consumer back to the lender credits disclosure so they can see where the cure was applied. All right, continuing on the topic of credits, because this is another issue that generates a lot of confusion. The loan estimate requires disclosure of costs the consumer will pay. So that is why the loan estimate, unlike the GFE, does not contain lender-paid broker compensation, because in the Bureau's judgment, that's something the consumer is, paying through rate or through an origination fee, but is not a separate charge that the consumer is paying. It shows up on the closing disclosure, but it does not appear on the loan estimate. Now, when it comes to lender credits or lender-paid charges, the Bureau has pointed to the general rule that the disclosures shall reflect the terms to which the consumer and creditor are legally bound as of the outset of the transaction. And so you disclose accordingly. If the borrower is obligated, but the lender or the seller perhaps is going to pay, then you disclose the charge and you disclose an offsetting credit. So if, for instance, you have a circumstance where the borrower is supposed to pay for the closing costs, but they're going to get a premium pricing credit, and the lender is agreeing to use that premium pricing credit to offset some of those closing costs, then you would disclose the costs and you disclose the premium pricing credit to offset it. If, however, the borrower is not going to be charged for the fee, the lender is going to absorb it as a cost of doing business. So say the lender is always going to pull credit, always going to pay a credit report fee, but it just doesn't charge the consumer for that, then you don't need to disclose it on the form. Excuse me, then, finally, you would disclose on the loan estimate, this is the one exception, you can still disclose, you're not required to, but you can disclose owner's title insurance that's going to be paid by the seller. That can still appear on the loan estimate. All right, and then the other point I just want to touch on here is that lender credits, and the Bureau is very clear about this in the rule, are subject to zero tolerance and cannot decrease absent a changed circumstance or other exception. So in the Bureau's mind, for instance, go back to the premium pricing credit example. If you've promised the consumer, or it's been disclosed that the consumer is getting $1,000 towards their closing costs, then that amount cannot go down unless there's been a changed circumstance or other exception. This makes it challenging when what you really want to do is pay for a specific fee, like the appraisal, for instance. And if the lender has made the decision that it's going to pay for the appraisal, period, doesn't matter what the appraisal fee turns out to be, could be higher, could be lower, lender's going to pay for it, then you just want to document that somewhere in the file so you can show that it's part of the transaction, and then you don't have to disclose it on the loan estimate at all. Because if you do it, if you go the process of disclosing it and then providing the offsetting credit, then just because it happens to come in lower doesn't mean you can necessarily reduce credit without something that meets the definition of a changed circumstance. Okay, let's see, how are we doing on time? All right, I'm going to wrap us up here fairly quickly so we can get to a few questions. But just to touch on the last few topics, and I do want to talk about this one because it's particularly important, delayed closings. There's been a lot of confusion around this. The Bureau's release yesterday was intended to address some of this confusion. But fundamentally, the issue is there is a point in the process where 3 business days before consummation, the consumer must have received the closing disclosure. And once that occurs, the consumer can no longer get a loan estimate. So what the Bureau was trying to do was get rid of the magic GFE, where the GFE provided at consummation just matches the HUD-1. And so there are a lot of questions about, well, okay, when can the closing disclosure be used to reset tolerances if you get late in the process? And the answer is it can, as long as the 3-day redisclosure period falls within the 4 business days before consummation. And so where you run into trouble is, the top of this slide just takes you through the technical details here. You run into trouble where you've issued the closing disclosure, and then the settlement date, closing date gets pushed back significantly, such that your 3-day redisclosure period doesn't match up with the 4-day cushion before the consummation date. I know that's hard to envision. I've got a calendar here that walks you through it, and basically what it shows, and I'll let you sort of review it on your own time, but the idea here is you have an original closing date of the 15th. It gets pushed back to the 23rd here, but unfortunately, when you've learned of a changed circumstance, so you've got the rate lock expiring, you need to provide a revised loan estimate, and you run out of time. Your 4 business days before the new closing date is just not quite in time to get you into that window. It's kind of an unintended consequence of the rule. There's disagreement as to how bad it's going to be. The Bureau said they'll look at it again if this proves to be a big problem, but they're not yet convinced it is. All right, very quickly, blank spaces. The Bureau says you can't use NA or otherwise put something in an inapplicable disclosure. Instead, you just leave it blank. This appears to preempt state laws to the contrary. Title insurance. You've probably heard by now that the way the Bureau requires title insurance to be disclosed can create conflicts with state law. And the answer to that, in short, is that an addendum can be used that provides the state law disclosure, but you have to disclose it on the forms the way the Bureau requires it to be disclosed. APR tolerances. This is another thing the Bureau tried to touch on and firm up yesterday, which is the confusion around when the APR becomes inaccurate. Because if it becomes inaccurate, that is a circumstance that requires redisclosure and a new 3-day waiting period, which can blow your closing date. So what the Bureau clarified is that the rules around inaccuracy of the closing disclosure haven't changed, and that in any instance in which the APR is disclosed and then it goes down, if the reason for the reduction is a reduction in the finance charge, so the rate's gone down and therefore the interest charges have gone down, or some fee that was previously treated as a finance charge goes away, then that is not a redisclosure event, and you do not have to wait an additional 3 days to close. There's been a lot of confusion around that, so I wanted to touch on it. Finally, the Home Loan Toolkit. This is the Bureau's publication that replaces the HUD settlement cost booklet. And basically the Bureau has updated it to coincide with the new disclosures so that it ties in with the loan estimate and the closing disclosure. Same rules apply for basically any loan where you're providing a loan estimate. You're going to provide this instead of the HUD settlement booklet. If you're still providing a GFE, you'll provide the HUD booklet. But it's not required for refinances, second lien mortgages, or reverse mortgages. So you have to deliver it or place it in the mail no later than 3 business days after the application is received, same as the loan estimate. And the same electronic delivery requirements apply as with the loan estimate as well. So the important thing here is you're going to need e-sign consent to give this to the consumer electronically, just like you would with the loan estimate. And you've got to get that consent before you give it to them. However, before can be immediately before. So it's permissible to set up an electronic disclosure process. This is what a lot of folks do, is where the consumer essentially provides the consent and then is immediately through an electronic process taken to the disclosures. It doesn't mean you have to get it, wait a day, get the consent, wait a day, and then send them the disclosures. All right, and with that, I will stop and turn it back over to Carl, and hopefully we have time for a few questions before we let people get back to their day.
Hey, Ben. Actually, it's Pam, and we did get a couple questions.
Great.
Perfect. And we did get a lot of questions, so we're only going to be able to go through a few. But the first one we have is, once the loan estimate is given to the borrower and the loan or the interest rate changes, is the lender allowed to lower lender credits, or are they held to the original lender credit that was on the original loan estimate?
Got it. Okay. So the way this works is that lender credits are subject to the zero tolerance in the sense that the Bureau views any decrease in a lender credit as an increased charge to the consumer. So just like if you were going to increase your origination fee, you would need a changed circumstance or a borrower requested change to, say, loan terms or products that justify the increase. You'd need the same for a decrease in the lender credit. So it would depend on, the reason why the rate's gone down. If the borrower's requested a lower rate and that lower rate comes with fewer credits, then you document the request, and that should be sufficient for a borrower requested change.
Thank you. Next question, with redisclosing the APR. We understand that we have to redisclose if it increases. Do we also have to redisclose if the APR decreases?
Right, so that's a great question and one that's been the subject of a ton of debate. And as touched on in the slides, the answer is basically no. In the event of decreases, you do not need to redisclose, as long as the reason for the decrease is a decrease in the finance charge that you previously disclosed. The APR is a function of the finance charge. And so if your finance charges go down because the interest rate's gone down or because some fee has gone away, then you do not need to redisclose. That begs the question, well, are there any APR decreases where you might need to redisclose? And the answer is, yeah, that could happen. If you basically just miscalculated the APR and the reason for it going down is not tied to the finance charge, then you might have to redisclose in that circumstance, but hopefully that should be a very rare occurrence.
Thank you. There's been a lot of talk now that the appraisal is considered zero tolerance. What happens when a loan officer discloses the appraisal fee, and then when the actual invoice comes in, the lender's charged for perhaps a fee plus mileage or even a re-inspection? Does this constitute a change of circumstance so they could redisclose the cost?
Unfortunately, no, it doesn't. The way the Bureau interprets changed circumstance is that it has to be specific to the borrower or the transaction. That has to be the source of the new information. So the fact that the cost just happened to be higher than anticipated is not in and of itself a changed circumstance allowing you to pass the increase on to the borrower. This obviously creates problems because we're familiar with all the struggles with folks who are perhaps not subject to these disclosure requirements, and they don't give you precise information. They view it as your problem, not their problem. This is going to have to sort of trickle down to all the providers who provide fee information and services in the course of a transaction, because ultimately somebody is going to have to eat that cost, but the Bureau says it can't be the consumer. Okay,
thank you. Someone asked, they wanted to know what's your opinion about the settlement service providers list. We know we have to state at least one title company, but do you suggest putting several on the list so they could be subject to the 10% cap?
Right. Okay. So this is, sounds like we're all on the same page with the rule. It only requires that you provide one who's available to provide services in that area, right? So you can't provide somebody who doesn't actually provide the service. They've gone out of business, so they don't operate in that area, because then you're basically forcing the consumer to choose their own and getting out of the tolerances in that way. Bureau doesn't want that. But what's perfectly permissible is to just put one on there, and so that that encourages the consumer to look for their own. Now, you could take a different judgment, which is that you don't want to run the risk of, or you want to minimize the risk of having to deal with somebody that you don't choose yourself. And if that's the case, then maybe you do put sort of, your three choices on there, and hope the consumer will take one of those. It's really how much you want to incentivize the consumer to choose somebody who's not on your list.
Thank you. Question came in, a few different questions came in regarding broker's fees. Are they disclosed on the GSE? Does lender paid comp show on the new loan estimate?
Got it. So a broker's fee that's charged to the borrower will appear on the loan estimate just like any other charge that's imposed directly on the borrower. However, lender-paid broker compensation does not appear on the loan estimate. The Bureau is very specific about this because the Bureau has made the judgment that that's not directly imposed on the borrower. It will be reflected in the rate, or it will be reflected in the creditor's own origination fees. It will appear on the closing disclosure. On page 2, there's a special column for charges paid by anyone other than the borrower or the seller. And in this case, the Bureau would require the lender-paid broker compensation to be disclosed in that column because it's paid by the lender in connection with the transaction.
Thank you. I know we are running a little late. I just want to ask a couple more questions. Could you explain the timing of the delivery of the closing disclosure? Some people, if they're going to deliver it to the borrower electronically versus regular mail versus overnight?
Yes. Okay. So, as discussed during the presentation, the core requirement is that it be received. The closing disclosure must be received by the borrower at least 3 business days before the date of consummation, which will generally be the closing date. Consummation is the date on which the borrower is contractually obligated, usually when they sign the note. But the issue is that in any circumstance other than in-person delivery, the mailbox rule applies, and that means it's presumed to be received 3 business days after it is sent by whatever means. Could be sent by email, courier, regular mail. The default rule is it's presumed received 3 business days after it goes out. So if I want to send it to the consumer by regular mail, I've got to put it in the mail 6 business days before the date of consummation. So I get the 3 business day mailbox rule, and then I am able to establish that it was there, even if I can't show it actually. The rule assumes it was there 3 business days before consummation. Now, what the rule says is you can overcome the mailbox rule because it does seem a little, absurd to send it to the consumer by email and still have to assume it takes 3 business days to get there. That is the way the rule works, but the Bureau said you can overcome the mailbox rule presumption with evidence of actual receipt. So, assuming you have your e-sign disclosures in place, proper consent, if you sent it to the consumer by email, say as a password-protected PDF, and the consumer provides confirmation that they got it, they send you an email saying, got it. Not enough to just show that they got the email. You have to need confirmation that they actually opened the disclosure. And that can be just them emailing you back and saying they received it. It can also be, and this is what a lot of folks are doing, a portal system, again, that takes the consumer, you email the consumer a link, consumer clicks on the link, they enter their password or whatever security features you might have, and then when they actually open the disclosure in front of them, the system logs the fact that they viewed it, and that's your evidence of receipt. What I say to people, though, is I think those portal systems are terrific, and I think they meet all sorts of privacy and security requirements, and it's a great way to go. But even still, because you can't control when the consumer actually logs in and views it, the safest thing to do is still to send that email 6 business days before consummation. And if you're not going to make sure you've got a really hands-on approach so that you can make sure the consumer opens it and you've got your evidence of compliance.
Great, thank you. This is going to be our last question, and thank you all for sending in all your questions to us. If you could just tell everyone what changes trigger the redisclosure's 3-day waiting period. Does the LE or CD need to be redisclosed if it's within tolerance or only if it's out of tolerance?
Got it. Okay. So the redisclosure of the loan estimate is about resetting the tolerances that apply to closing costs, and that must always be done within 3 business days of learning of the changed circumstance or other exception. But I think this question is really one about once you've provided the closing disclosure and it's been received 3 business days before consummation, what are the events that trigger a new 3-day waiting period? Because most changes that occur after that initial closing disclosure is delivered can just be reflected on a revised closing disclosure at closing. But there are 3 circumstances where you need to redisclose and provide a new 3-day period. You add a prepayment penalty, you change something fundamental about the product. There's a specific list about this, but the example would be going from fixed to variable, adding an interest-only feature, those sorts of product changes. And then the last is what we talked about before, which is the APR becoming inaccurate. And inaccurate has a very defined meaning. As covered, it's generally not going to apply to decreases in APR if they're based on decreases in the finance charge. For increases, then it's going to be an increase above the APR tolerance, which is 1/8 of a percentage point for most transactions and 1/4 of a percentage point for irregular transactions. So it is the same tolerances that apply today will apply to the closing disclosure.
Great. Thank you so much. Carl, do you want to sign off on everyone?
Sure. Thank you very much, Pam, and thank you very much, Ben. First of all, I'm very happy with the amount of people that have registered for this call today, this webinar. In fact, I was told by NMP that this was a record for them of how many people registered for this call, and it's proof that there are more and more people that are looking for as much information on this topic as possible. And again, we're 42 business days out from the change. So I would invite everyone to sign up for REMN Wholesale's next webinar on July 21st. We'll be getting that link out to everyone. And again, we'll be sending out the recorded version of this webinar soon. And I want to thank National Mortgage Professional Magazine and Ben Olson for providing some very important information for all of us today. So thank you very much, everyone. Have a great day, and we look forward to all the changes for August 1st. Thank you very much.